I'm attorney Phil Giacino, and this is Finding Common Ground here on WLIY Altice. My guest tonight is Jorge Rosario. Jorge is with the Legal Aid Society. I see him quite often before referee Kelly. That's your assigned courtroom for now, correct?
Yes, it is.
And he is also a retired JAG, a major with the United States Army, and with Legal Aid Society, he's with the Children's Law Bureau. Welcome aboard.
Thank you very much. Pleasure.
We have three segments tonight. Jorge will be with me for the first segment. The second segment will be frequently asked questions, and the third segment will be American exceptionalism, which is the Angel of Marie's Heights. The first topic I want to talk about is child custody, which we've talked about on other shows, and also the role of what they call the attorney for the child. I'm a throwback, so I say a lot of times law guardian, but that's an acceptable, it's like AKA law guardian. So I'm going to have Jorge do the honors of telling the audience what a law guardian or what the attorney for the child does.
Thank you. As you mentioned, it used to be called law guardian. There was a change some years ago, I think around 2007, where the chief judge created the rules, 7.2 of the judiciary rules. And it's something that your viewers can look up online on eCourts and see what that rule specifically says. But essentially what it did is it changed the way attorneys represented children. Years ago, the representation of children was that the attorney took on the role of guardian, meaning that they made the decision as to what was best for the child.
When I was there, that's how it was. And
yes.
I left in the 90s, so you're talking about 07 when it started to change.
Yes, and started to change to what we have today, which is they changed the term as well to attorney for the child, in short AFC. And the reason for that was to make sure there was an emphasis on the change of how attorneys should do their job. When you have an older child, the attorney is supposed to, just like any attorney would, with their client, speak to them, counsel them, but also get their point of view. What is it they wish for the court to do on their behalf? So even if we disagree, we have to advocate for what that child says. But in some instances, it can change. If it's a juvenile delinquency case, that we also do, the AFC, similar to a criminal attorney, would have to advocate zealously for their client, right? There's no in between. However, there are some nuances, as always, in the law. So when you have younger kids, and maybe they're at the age where they don't really understand the ramifications of what they're asking for, at that moment, the AFC can go against the child's wishes if certain factors are met. If they don't really understand or don't have the capacity to understand the dangers posed, if you have a parent who is abusing drugs and is in bad shape and poses danger to the child, at that point, even if the child wants to go back to that parent, the AFC can tell the court and must tell the court that what the child's wishes are, but that they're advocating something else.
Right. So for instance, let's say you had a 15-year-old client.
Yes.
And the client wanted to go back with dad because let's say there were no rules and dad was very lenient and mom was the disciplinarian. You'd have to tell the court the child's wishes, but you could also tell the court, let's say, the pitfalls of that child going back, correct? Going back to dad. Right,
and it gets so nuanced that if the pitfalls are that dad isn't, pushing rules such as no drinking or drugs or something that would put the child in danger, then yes, that's how we would do it. If there's nothing that we can specifically point to that is a danger or really bad to the child, we still have to say, no, my client should be with the dad, even though dad is not a disciplinarian. And this is where a lot of parents have that misunderstanding with the AFC, because they look at it and say, well, aren't you supposed to be doing what's in the best interest?
Like just a mouthpiece,
yes,
something like that.
Yeah, but no, but it's the court's responsibility to do what's in the best interest, as long as there's no danger.
With an attorney, even if I disagree with my client, I wouldn't bring out to the judge, let's say, my client's weaknesses, but you can say, well, even though my client wants to go to dad has a drug problem, and it might not be the best place for that child to go.
Absolutely.
That's your job.
Yes, because that's where you have to figure out what the role is now, right? It's not just simply advocating for your client. Now you have to look out for the safety of
Right.
your client.
And the younger the child, the more of a responsibility you have. Because if the child was 5-year-old, you're not really going to say the 5-year-old wants to live with dad. You can impose your judgment.
Yeah.
Whereas a 15-year-old, you have to be, a little, like you said, more nuanced.
Yes, we have to certainly be nuanced with the 15-year-olds. Or the 5-year-old, there's 5-year-olds that are very mature, but as long as it's they're okay, then you can still say, well, the child wants to spend more time here or there, but again, it changes and it varies.
I get this question asked a lot of me. I'm pretty sure I know the answer, but I'm going to let you give your answer.
Sure.
If you have a child, let's say, who's 5 years old,
Yes.
do you say to that child, who do you want to live with? Whereas a 15-year-old is no question, I know that.
Yes.
Or 14 or even 13, where do you want to live? If you have a 5-year-old or a 6-year-old, what do you say to that child as to what their preference is? How do you phrase a question?
Well, first I try to avoid that direct question,
Right.
as you know, because you're putting that child in a position where they love both their parents, and you're asking them to make this choice. So instead, what I try to do is I ask many different questions. What do you do with mom? What do you do with dad? What do you enjoy doing with mom? What do you enjoy doing with dad? What don't you like? At mom's. And
You get a sense.
You get a sense, and if the situation is like any other normal situation, where a kid's going to say, "Well, dad tells me to go to sleep too early, so I don't want to live there," then is that
Right.
really a good reason?
The kid's not articulating a good reason.
Yes.
The other thing, too, is you get a sense, like a question I like to ask is, if you misbehave, what does mom do?
Yes.
Or what does dad do?
Right.
Well, dad takes the belt out. Right there,
Yes. Then you
you
know
got
there's
your
a
answer.
problem.
Right.
Absolutely.
But I think that's very important. That's why when I do a custody trial, I always try to bring out how the child is reprimanded or what the parent does. That's important. It's easy when you're playing a game or you're going to the park. But when a parent has to parent
Yes.
and the child is misbehaving, how does that parent handle that child's behavior?
Right. And many times, and this is where sometimes people forget that even with a child, well, counselors have law. So
Right.
with a 5 or a 15-year-old, we still may have to counsel them. Very differently, of course, with a 5-year-old. And if they say, well, I don't like dad because dad makes me go to bed early.
Mm-hmm.
Well, and then I might say, well, why do you think dad's doing that? And sometimes they answer their own question. They say, well, because he wants me to get enough rest so I'm okay at school.
Right.
And it's like, isn't that a good thing? Yeah, I guess. And you get that
Mhm.
kind of answer. And then they realize, well, the parent that they're saying is mean isn't really that mean.
Right. They're
Yeah.
being a parent. Now, you're with the Children's Law Bureau. They also have private attorneys for the child. What is the difference? And what is the role of the Children's Law Bureau, which is under the umbrella of the Legal Aid Society, correct?
Yes, absolutely.
So what does that bureau do?
Well, we are a contract agency. We contract directly with OCA, Office of Court Administration. So the Office of Court Administration ensures that kids have representation. Within OCA, they also provide funding for what we call the 18B panel that most of us are familiar, and that's a section of the county law which provides for representation for the indigent as well, and for children. So the panel provides AFCs that are trained, and also what the court does is that they make sure that they have a good background and they understand
Right.
how to represent children. And compared that to our department, which is the Children's Law Bureau, we have a staff of attorneys of 20 attorneys at the moment. We also have on staff 7 social workers.
And that's between Riverhead and Central Islip,
Correct. Yes, we have both. We do cover both locations. We cover all the way from the tip of Long Island to the little islands that we have off of Long Island. As long as people inhabit them, we're there. If our clients get sent upstate, we'll represent them. Maybe have to travel at times, make sure that we properly represent them. But we have that access to the social workers that have a lot of experience dealing with children. So we have that added bonus.
Now, generally, if both parties have private attorneys, someone like yourself would be appointed to represent the child.
Yes.
if one of the parties already has, let's say, a legal aid attorney, then you wouldn't get the call.
Right,
They
because
would have to do a private attorney because
Yes.
of conflict of interest.
yes, absolutely. So we do have a family court a department, and they represent the adults, so we wouldn't be on the same case.
Because it's
So
like
that-
the same law firm.
Yes, it is the same law firm, and so they would have access to the files and computer systems. So we make sure that when we get on a case, we do what we do a conflicts checks that we call it, and if we can't take it, we notify the judge or the referee that we can't handle the case, and that's when the private bar.
Correct. And that's like what I did for 5 years, many years ago. I was a private, at the time, law guardian, attorneys
Yes.
for the child. Term hadn't come about.
Yes.
Now, what kind of continuing education do you get, or are you required to get as an attorney for the child?
Well, the state has its directives, but also our department has our own internal policies. Each year, the state will put on a CLE for AFCs. This past year was in Manhattan. In the past, we've gone to Syracuse, and it might be 1 or 2 days of training.
So didn't you try to get it to Vegas or Hawaii? Is that
No, I wish. That would be an excellent-
Syracuse in the winter? Come on.
Yes, that's what they offer us. So,
But you got to do it. It's
yes.
mandatory, right?
yes, and what we do internally is we also send our newer attorneys to NIDA training, and it's a week-long training, 6-7 hours a day, so they can
Wow.
pick up their trial skills. But the ones that are done by the state, it's specific to AFCs, and also at the courthouse here in Suffolk, the administrative judge also mandates that everyone take at least once a year an update of
Right.
CLEs.
And in addition to any other types of classes you may take.
Right, and the thing is, the important thing is not just about the law, but we also take courses in the science behind the adolescent brain, about the development
Right.
of the child, so that way we can understand ourselves how to advocate and also what to tell the court. And the courts also take these courses as well, which are excellent.
Now, you were a JAG officer. I want to get that in. You were a JAG officer.
Yes.
For how long?
About 12 years. Before that, I was a military police officer.
Okay.
Before that, I was in logistics.
So obviously in the military you didn't deal, or maybe you did, if it could have been domestic incident or something, but
Yes.
oh, you did?
Yeah,
Okay.
actually we did, because the military, the Army sends you anywhere. So wherever the assignment is, you go. I've been stationed at Fort Drum. I've had domestic situations in Germany when I was covering what we call legal assistance. So we would have people come in. As a case in Germany, I had a gentleman come in that the military was coming down on him because they thought his children were too skinny. Right, so they were trying to say that maybe they were malnourished.
That would be like a neglect petition
Yes.
in Suffolk County where they would
Correct.
say either the child's not being fed properly or abused or neglected or not going to school. The whole
Right.
gamut of things a parent can be
Correct.
charged with.
Correct. So my role at that situation actually was advising the adult, and because I had the family court experience, I was able to advise the gentleman, the service member, of what to look out for. And even if, it was one of those cases that if you looked at him and his wife, they were both what I would call super skinny individuals. So I think there was a lot of genetics involved there
Sure.
too, and so I wanted to make sure his due process within the military was protected.
Right, right. Now, you've been in family court for quite a few years.
Yes.
Did you start out as an attorney for the child when you first went to family court?
No, I started representing adults in the family court bureau, and actually before that I was in the criminal bureau, so I was representing
Okay.
those accused of crimes, and then moved to representing the adults who were charged with neglects or the custody visitation situations.
Right. Now, the neglect is a different focus, obviously, than a custody case.
Yes.
So tell us a
Absolutely.
little bit about the difference, what you would be doing maybe differently in a neglect case where a petition is filed alleging abuse and neglect, and a V-docket custody case.
As an AFC on the neglect, a case can come in on an emergency basis. So sometimes the court is asking you to represent a client you've never met. You're looking at a petition and trying to gauge to see what would be best for this child.
Almost like some criminal cases where all of a sudden they say, you're assigned, and and you're
Yes.
standing next to the guy for the first time, and you got to think on your feet what's best for that.
Yes,
But
absolutely.
there it's an adult. Here now it's a child.
Yes, yes. So, in those situations, you're trying to ascertain how serious, how imminent is the risk. Can measures be put in place to protect the child without having to remove the child? Because by removing the child, are you going to traumatize the
Right.
child? Are you going to make it difficult for this family to reunite? And with all the studies showing that, that's really the last thing you want to do, because you're going to hurt the child more than you can ever imagine.
Right, and just for the audience, when a neglect comes in, and if the child has to be placed, they always try to place the child with a family member, of course.
Yes,
Could be a
correct.
mother, a grandmother, it could be an aunt or an uncle. The last resort would be foster care,
Yes.
even on a temporary basis.
Yes.
And it is more urgent, these neglects, because a V docket comes in, it can be adjourned, you have time to talk to the child.
Yes.
I remember one time, remember Judge Genshi?
Yes.
I tried a
absolutely.
case, I was there till 9 at night, because with a neglect, you have to deal with that case.
Yes.
Kids were in, at the time, 2 kids were in a psych ward, 1 child was in foster care, and the judge had to render a decision that day.
Yes.
And
it's not unusual that
No.
you get late cases, but they have to be decided because people's lives are at risk.
now, having been in the criminal side and the family court side, what kind of things do you think could be improved on? On this show, we talk about that a lot. And again, I'm not knocking family court. It's a very tough job. That's
Absolutely.
probably one of the toughest jobs you can do, is to be a family court judge. Think about it. It's hard enough what we do,
Yes.
but they have to make the decision.
Yes, they have
We
to
got
make
the
that
easy
tough call.
part. We just
Absolutely.
fight like hell for our
Yes,
client.
absolutely.
They got to make the decision. They got to hear from the petitioner's attorney, respondent's attorney, from you, and then say, what's really going on here?
Right.
That's a tough job.
They figure
What
out.
kinds of things maybe have you seen improvements made through the years, or what could the family court system do to better protect children?
Well, I've seen a few things that have absolutely improved. There's always, of course, room for improvement. Just recently, about a couple of months ago, I spoke at the New York State Commission on parental rights, and the commission is put into place to go around the state to hear from folks to see what can be improved, what rights the parents have, but how to protect those rights. We know what they are, but how do we protect that? And at the same time, hopefully unify that family. At that commission, some of the suggestions that I provided was that as soon as somebody comes into the courthouse and they're asking for a certain petition, that be handed something to say, if you're looking for this kind of case, look at these attorneys. Having counsel before they even walk into the
That's
to
a
the
good
room
idea.
the first time,
Yes.
because as you know, so much time is wasted at times. A person files a petition, 3 weeks later they're brought into court.
Right.
Then everybody's trying to figure out who's going to represent who. They adjourn that
Right.
for another 2 or 3 weeks. So these folks have real family issues that should be dealt with. So my suggestion was, as soon as somebody's asking for a document, a petition, hand them the referrals, hand them sheets, hand them the Bar Association
Right.
information so they can start
You
seeking
can give them
out.
all my name. That would be
Absolutely. but as you know, when clients come to you before their cases before the court, they have a better chance
right.
of resolving the issues, what brought them
And
to
the case
court.
can move faster.
Absolutely.
Because so many times they appoint an attorney for the child, and then they have to adjourn it because you got to talk to your client. Your
Yes.
client's not there, so that takes a little more time.
It takes time.
Or the person comes in and they appoint them an 18B attorney, let's say,
Yes.
and they're meeting for the first time. You're right. If they come in, a lot of attorneys give a free consultation.
Yeah.
Talk to the attorney, become a better consumer, so that
Oh.
when you're appointed an attorney, you know what questions to ask that attorney
Absolutely.
and what to tell them, because they're going to
Absolutely.
need information. Maybe you show up with some information that you could give the attorney right away. It could
Yes.
it could be something that's posted in social media. It could be a photograph of a bruise, something that attorney can say, you know what, we got to take immediate action. And you don't get that when they walk in for the first time without any knowledge.
No, and it takes time, as you know. But even just today, one of the questions that you had asked was, what things are we doing well in the court system? And I did attend a session where the administrative judge, Judge Whalen and Judge Lugercio, were talking to folks about drug treatment court. And they've made many improvements with drug treatment court. We know about the opioid epidemic, but how do we help that family? How do we help
That's a
the
big
kids?
problem in family court.
A huge problem. But one of the things they're doing now is really focusing, not just keeping the child away from the family, but how do we do our best to put them together, work together, get everybody the services they need, and as quickly as possible,
Right.
reunite the family.
Because when a case comes in under an end docket, generally it's to reunify the parent and child.
That's
the
the
parents and
goal,
the child.
yes.
Right. And that stays that way until the parent messes up many, many times, and then it can
Yes.
change.
Right.
But initially, like you're right, you
Yeah.
want to, you say, all right, the mother or father has a drinking problem or a drug problem, but we know at some point they got to get that kid back.
Yes.
That's the goal.
Yes.
And how can we integrate?
Yeah. I mean, and at some point, some people don't get the help as quickly. So what they call achieving permanency for the child, that permanency may be having that child adopted, or maybe having grandma be the
free for
guardian.
adoption.
Yeah, the free for adoption, or having grandma or somebody else take guardianship over that child, and that may be necessary. But they're really looking at a case by case, which I think years ago, I don't think it was that way. I think we had this expectation that if you took a child away from somebody, they're going to fix themselves. But
Right.
with the levels of addiction from opiates and
Oh, I
other
know.
things, people don't.
But it's
you
even
lose it.
with the opioids and fentanyl, it's a whole new ball game than
It
it was
is.
years and years ago.
Absolutely, absolutely.
Some of these things, it's amazing to me. And then it gets complicated now because marijuana used to be a reason why, let's say, someone could get their parenting time scaled back or potentially not have their kid for a while. And now with the medicinal marijuana, a lot of people have the card.
Yes.
And I tell them, it's like alcohol is legal, but if you're a drunk or you're an alcoholic, you could still lose your child even though it's a legal substance.
Yes.
So you can't just say,
You
oh, well,
can't abuse the
you
substance.
can't abuse it. Anything can be, even legal, even if you have a prescription.
Yes.
If you're overdoing it, a judge could say, look, you got to go to a program.
Right.
Now, what are the resources? I know when a case comes in, let's assume each party has an attorney, and then the judge says, Mr. Rosario, can you take the case? You check.
Mhm.
Yes, I can.
Yes.
What other resources do you have at your disposal to help you either not so much make a determination, but to how to counsel that child and get the child the services he or she needs?
On some of our very serious cases, if a child's been abused, sexual abuse, I've dealt with many cases of that nature, I'll pull in a social worker with me, right? And allow me to ask the questions together, or I'll let the social worker initiate, because they understand what the child might be going through better than I.
Right.
Even though I've had the experience, but they're going to look at it through a different lens. I'm looking at this child also through a legal lens. How do I protect the child legally? They're looking at the emotional and the well-being.
You bring in the expert.
I bring in the expert, but it allows me to do two things, bring in the expert. If they're going to help me help this child and maybe do an assessment and say, I think the child needs something, or if the child is misunderstanding something too, right? I mean, kids
Oh, sure.
misunderstand situations. So they will also help, because if I have to bring in a neglect petition and it's not the county, I have to prosecute the case, which have had done in the past. So now I need a witness.
Sure.
So now having that social worker can play a dual role. They can help me with it, but then I could utilize that social worker to state to the court what the child said, because as you know, he or she is admissible on neglects.
Absolutely, yes. And they also have things like 1034,
Yes.
where they do a report, so you get additional, all the attorneys
Yes.
and the judge get
Yes.
additional information. You might not know that someone had a prior,
Correct.
or there might be an issue with the school or things like that. So those are other resources, or a home study,
Home studies.
forensics.
Probation, you can ask probation to do a home study. We can have our social workers do the home study. And as you mentioned, the 1034, which is a great tool, that's when the judges are ordering Child Protective Services to do an investigation.
And you get like a nice little summary
Yes.
of what's going on.
And they get about 60 days or so. Within that time, they have to produce a report to the court. And as you said, now, if there's background, now we get all that other information.
Right. Now, what about CPS? What's your contact with Child Protective Services?
Well, what we do with Child Protective Services, if I get a case that we have some concern, I direct the social worker to make a call to CPS, and either through the hotline or file something and communicate with CPS.
And get access to records?
Absolutely, especially if it's through a neglect. It works a lot different, a lot more difficult on a custody, right? Because you can't get that from that agency under a custody.
But neglect.
But a neglect is much easier, and we keep constant communication with CPS. We have their phone numbers, emails, and make sure we can communicate for the benefit of the child.
Mm-hmm. Now, what things do you see in the future that the role of the attorney for the child might be required to do? Do you think, just like a change from my day to your day, do you see another, let's say, evolution or any kind of change in your responsibilities?
I think so, because there's still a lot of disagreement between the newer role of the AFC. There are still folks that believe that as an AFC, you should be able to go against your client's wishes if it's not in their best interest to follow what they want. So we have those. We still have that tug going on between it's a big rub. So I can see that shifting, or even shifting slightly.
And I guess also you have to you have your guidelines you have to follow.
Yes.
But I guess within those guidelines, you have your personality. You have, just like a judge.
Yes.
There are some judges that'll talk to the attorneys for an hour. And then there are some judges that'll be like, hey, you guys can't settle it, go to trial.
Right.
So you have to find a way that works for you. Like you were saying, what kind of questions you ask the child. You might have an outgoing personality where you can engage the child.
Yes.
Another attorney for the child might not have that, and they may have to find their own way.
Absolutely.
Because you gotta reach these kids sometimes.
Absolutely, and also because even the guidelines, there's always that gray area, because they don't tell you what age, when they're a certain age. They leave it up to the discretion of the attorney to determine whether the child has the capacity to understand something. Right. So now you have to make an assessment.
And you're the one going to speak, because the judge doesn't come out and speak to the child.
Correct.
That can happen at the end, just very briefly, because we got to wrap things up. But let's say there's a trial. At the end of a trial, there's what they call an in-camera interview. The child or children go in the back with you, with usually a court reporter, a court officer, and the judge. The attorneys are not allowed back there.
Correct.
We can submit questions which you may or may not choose to ask.
Yes.
And that's the chance for the judge to really hear from the kids.
Yes.
But you're in that room because they're your clients.
Correct. Yes.
We're not. We're out.
Right.
We're usually not even there that day.
Yeah.
We don't need to show up. But Jorge, I really want to thank you for coming in today. I think this was a very informative show, because a lot of people, what you do to someone like myself, I know. I've been one, I see it. But the people that are coming into the court system, they're like, wait, my kid's going to get an attorney? What does that mean?
Absolutely.
A show like this is helpful, and I've seen you in action. You're very good at what you do.
Thank you.
You know, not just you, but a lot of the people on that panel, it's a tough job.
It is a
I
tough
gotta
job.
say. Like I said, the only tougher job is the judge him or herself.
Yes, I do not envy the decisions they have to make.
And I heard somewhere, seriously, that their life expectancy is like even a little bit shorter, I'm serious, than like the general population, because the stress they have to deal with. And also when they go home at night, like I said, you and I fight hard.
Yes.
And we leave it all out.
Yes.
We go back home and we say, you know what, we did everything we could for that child. The judge is making a decision. Does he go with Uncle Ernie or Aunt Sally? And if something happens to that kid, even though the judge is not at fault, they're making a decision. They don't have a crystal ball.
They're human.
They're human. But I really thank you for coming on.
Thank you so much for
I'll have you on
me.
again sometime when we'll talk about some updates.
Thank you.
Okay?
Thank you very much.
Thank you. Welcome back to Finding Common Ground here on Altice. I'm attorney Phil Giacino. This segment will be 15 minutes, and I will be answering frequently asked questions. These are questions that come to me on a daily basis from clients. Sometimes people send me an email. Sometimes they send me a text. Sometimes on Facebook, believe it or not, I get a private message where these kinds of questions are asked of me. So these are important questions. The first one, and before we begin, it's going to cover family law, criminal law, and 2 questions on wills and estates. First question people ask me all the time: in a divorce, who gets the house? Well, that's a question that can't be answered in 30 seconds, but I'll give you my answer. In a divorce action, and this is not in family court, this is Supreme Court, the court has to make a determination on what the marital estate consists of, and then how those assets get divvied up. We could be talking about a house, cars, bank accounts, a coin collection, a doll collection, you name it. Anything that has value is considered an asset. So we're talking about the house right now. The court will look at whether or not the parties can keep the house. In other words, keep one of the parties in the house. Let's say the parties have a high school student who's in 11th grade. That high school student, in all likelihood, does not want to have to move, because they may then have to end up in another school, and if they're a sophomore, junior, or senior, they're not going to be too happy about that. If they want to move, then that's fine. So the first thing the court will do is say, all right, who's going to have custody, and does that parent need to stay in the marital residence? And if they can afford to stay in the marital residence. If there are no children, or if the children are very young, let's say you have a 2 and a 3-year-old, the court might say, look, sell the house, the kids aren't in school anyway, divvy up the proceeds to the sale of the marital residence, and then each of you can rent an apartment or buy something, depending on how much of the proceeds there are. So what the court will do is, again, look at the financial position of the parties. Is there enough money to carry the house? If they're in foreclosure, the court's not going to say, okay, the wife can stay in the house. They might be able to do that, but the court's going to say, I can't cut an order that gives the wife, let's say, exclusive use and occupancy of the house long term if the parties are about to lose the house. The next question: what is a preliminary conference in a divorce action? When 2 parties come together for a divorce, and assuming it can't be settled out of court, they have to come to court. The first court appearance is called a preliminary conference. That takes place in the Supreme Court of New York, the matrimonial part. The preliminary conference sets forth what needs to get done to proceed. In other words, papers are filled out that address what documents have to be exchanged. Do we need an attorney for the child? If there's a custody case, we may need an attorney to represent the children's interest. Do we need any immediate relief? So in the preliminary conference stipulation, the parties might put in there that the husband agrees to pay the wife $300 a week for child support, or some other amount for maintenance, rather than the attorneys have to do battle and make motions. It also sets forth how far back the parties have to go to exchange documentation. It might be 3 years. It might be 5 years. I had a case one time where there was a reason, but we went back 9 years. You don't see that as often, but there might be a reason. So the parties come together in court. A preliminary conference is drafted by the attorneys. They sign it, and then the attorneys speak to the judge, tell the judge a little bit about what's going on. Some judges will come out to meet the parties and say, hi, I'm the judge on the case. You have 2 good attorneys, do what you have to do, exchange the documentation, and I'll see you in about 6 weeks. Some judges don't come out, and the attorneys go in the back and they talk to the judge about the case. I know sometimes the clients are not happy about that because they want to be part of the proceedings, but it depends on the judge. I have no say in the matter for the most part. Sometimes you could say, Judge, I think you need to come out to talk to the parties, but often it's just to set them straight if there's a problem. Like if one party is harassing the other party or interfering with the other party seeing the children, the judge might come out and say, look, knock it off, do what you have to do, listen to your attorneys, and don't interfere with the other party's right to enjoy their house or their children. Next question: what does discovery mean? Now, I just talked about preliminary conference. The preliminary conference sets forth what disclosure has to be exchanged. Are we talking tax returns? Are we talking business returns? Are we talking bank statements? Financial statements of net worth? A whole bunch of things that the parties need to exchange. Could be canceled checks. It could be receipts. Whatever is particular to that case. Now with discovery, and another term for discovery is disclosure. Remember in My Cousin Vinny, and I'm saying something that Judge Gargiulo used to use and I'm just stealing it from him. He used to do divorce. He used to have the parties appear in his courtroom, and he would say, remember my cousin Vinny? And I think her name was Mona Lisa Vita, Vinny's girlfriend. She said to him, it's disclosure, you D-head. He has to give it to you. What she was talking about was documentation that is required by law to be exchanged. So those things I talked about a little while ago, bank records, tax returns, by law, the other side has to give them to you. And you have to give yours to the other side. It goes attorney to attorney generally. But if you don't do what you're supposed to do, the court can get on your case. So if we come back, the judge could say, counselor, talk to your client. If he doesn't turn over his bank records and the other side has to make a motion, I'm going to give them attorney's fees. Or I'm going to preclude you from bringing out those records, which might not be what the other side wants. I don't want them to be precluded. I want to see them. But the judge has power to impose a remedy that could hurt the party that's not cooperating. So discovery, disclosure is just documents, information that gets exchanged so that both attorneys know what this case consists of. If I don't know what the marital estate consists of, how could I ever try to settle this case? Is there a house? What does his tax return say? What does his W-2 say? Does his W-2 say he makes $100,000? Or does his W-2 say he makes 30? I need to know that, because how am I going to calculate child support? How am I going to calculate spousal maintenance or other things that that party has to pay? I need the information. Next question, and this is a criminal question. What is the difference between a felony, a misdemeanor, and a violation? Those are the three levels of criminal conduct in the penal code. A felony is the most serious. A felony is punishable by more than a year in jail. It doesn't have to be, but it's punishable by more than a year in jail. And there are different levels of felonies. You have an A felony, like murder, a B felony, C, D, E, and F. And with those felonies come different levels of punishment. So with a felony, a person can get 25 to life. A person can get 1 1/3 to 4, 1 to 3, 2 years, things like that. Felony is the most serious, and a felony can affect somebody from getting certain jobs down the road. Because some employers say, have you been convicted of a crime? That would cover a misdemeanor, which we'll get to in a second. Or they might just say, have you been convicted of a felony? Felony is the most serious of the three. The next one is a misdemeanor. A misdemeanor is punishable by up to 1 year in jail. A misdemeanor could be driving while intoxicated, could be assault third, could be aggravated harassment. These are serious, but not as serious as a felony. And they're usually treated in a different courthouse. Whereas if you're indicted on a felony, or you sign a Superior Court information on a felony, you'll be in Riverhead, here in Suffolk County. But with a misdemeanor, you'll be usually in Central Islip, or potentially one of the village courts. So a misdemeanor is not as serious. It's still considered a crime, criminal activity. A violation is something relatively minor. It still can get you up to 15 days in jail, but it's still not a crime and something that usually results in a fine. Whereas a felony and misdemeanor, if you don't go to jail, you can be placed on probation. A violation would be harassment. It could be being in a park after dark. Those are relatively minor violations. You still have to go to court. Leaving the scene of an incident with no injury, that's a violation of law. Tickets, speeding tickets, they're generally a violation of law where you usually get hit with a fine. Or an ACOD, meaning if you stay out of trouble for 6 months, the case will be dismissed, adjournment in contemplation of dismissal. The next question is, can I get a jury in a divorce or family court action? The simple answer is no. On those cases, the judge or the referee, or if it's child support, the support magistrate, make the decision on the case based on the evidence presented at the hearing. No jury. Can I get a jury in a criminal case? The answer is yes, you can. If it's a misdemeanor or felony, you cannot get a jury trial for a violation. I've tried some of those where the client was charged with, let's say, harassment. You get a trial. The judge will hear the evidence and make a determination. Now, who gets to decide if there's a jury trial in a misdemeanor or felony case? It's not the prosecutor. It's the defense attorney, the defendant. So if the defense attorney feels that he doesn't want a jury, a judge might be better for this particular case, the prosecutor has no say in the matter. The defense attorney can say, I want the judge, it's called a bench trial. The judge would decide. Or I want a jury. If it's a felony, you have a jury of 12. Misdemeanor, a jury of 6. And of course you have alternates. Next question. If my case is in Supreme Court, can I file a petition in family court? So let's say there's a divorce pending and one of the parties said, you know what, this case is dragging on, or I don't like the judge. I want to file a petition for child support in family court, or I want to file a petition for custody or parenting time. Can you do that? The answer is no. You can, but it will get kicked to Supreme Court because there's a case called Poliandro v. Poliandro, which says that once a case is pending in Supreme, certain issues about that case, like I said, custody, parenting time, child support, those issues have to stay in Supreme Court. The exception to that would be an order of protection. Although Supreme Court can handle orders of protection, generally the Supreme Court judge will say, go to family court, if that's where you want to go, and file your petition for order of protection. Or a neglect case. Let's say there's a divorce case pending, and one of the parents is accused of neglecting or abusing the child. The county can file a neglect petition. That's an abuse or neglect. It's under an N docket in family court. That can go to family court. Now, because of an integrated system that we have now, Judge Krecker sits and he handles certain types of cases. Divorce, orders of protection, family court, things where the parties would be in more than one court. So you might end up before Judge Krecker. But as a general rule, you're in Supreme Court, that's where you stay. Next question. What is the difference between marital property and separate property? I could go on for about an hour and not cover everything. Generally speaking, marital property is any property that the parties acquired during the marriage. When I say acquired, it could be they purchased, they were given as husband and wife. It could be that they inherited as husband and wife, a gift, they purchased, they won as husband and wife. It could be a lottery ticket that they won as husband and wife. That's marital. Separate property would be any property that the parties had before the marriage or that was purchased during the marriage with separate property funds. So if a person gets married and they had $1 million before they got married and they use some of that money to buy a house they keep in their own name, that is deemed separate property. And one last question, we got to wrap this up. Why do I need a will? If you die without a will, the laws of intestacy kick in. So let's say you had 5 children and you want to leave your property to 2 of those children. You can do that. You can leave it to none of them. You can leave it to all of them, whatever you want to do. However, if you don't have a will, when you pass away, those 5 kids will share equally in your estate. So it's very important to have a will. It's also important to have a power of attorney and a healthcare proxy. These are things that you can contact an attorney about, and they will advise you as to what is in your best interest. Next week, when we do our next show, we will have another set of questions, which I call frequently asked questions. We're right now about done with segment 2. Stick around because segment 3 will be about American exceptionalism, and the issue will, not the issue, but the topic will be the Angel of St. Mary's Heights. Segment 3 is a segment that I call American exceptionalism. Each week, I finish my show with that topic. The first time we did it, we had Abraham Lincoln. Then we talked about George Washington last week, where he used his knowledge of the weather to help win the American Revolutionary War. Tonight, we're going to talk about somebody that's not as well known. In fact, when I say his name, you're going to say, I never heard of him. His name is Richard Rowland Kirkland. He is better known to history as the Angel of Mary's Heights. Take yourself back to December 13, 1862, Fredericksburg, Virginia. The Southern Brigade had formed along a stone wall and was raining down fire on Union troops. And on the night of December 13, 1862, the walking wounded made their way to the field hospital, but many men were too injured to make it back. So picture the North on one side, the South on the other side, and in between them, many, many men suffering. A lot of Northerners and a number of Southerners. And the men who were on each side of the fighting could hear the screams and cries of these men as night came, as night fell. So Richard Rowland Kirkland asked his Brigadier General Kershaw if he could render aid to the men suffering. And actually it was the Union soldiers that were closest to where he was. But it didn't matter to him. He wanted to help them out as best he could. At first, Kershaw said no. So Kirkland came back and he said, "Can I go there under the white flag?" And Kershaw said, "No, you can't do that. That would be like surrendering." So apparently Kershaw let him take his chances. He filled up a bunch of canteens and he went out into the no man's land between the North forces and the Southern forces. And he went back and forth to each suffering man with a canteen of water. And he ventured back and forth several times, at first helping the Union soldiers, but eventually helping all of the soldiers. And not only giving them water, it said that he gave them some warm clothing and blankets. Remember, it was December. Even though it was Virginia, it was still cold out. And during that time, nobody from the North fired any shots on him. And it became obvious to both sides after a while as to what Kirkland was doing. And they had an admiration for him. And to this day, Sergeant Kirkland's actions remain legendary in Fredericksburg. Because think about it. Here's a man who, once he hit that field, he was fair game. He was a Southern soldier. The Northerners could have easily shot him, but they didn't. And part of the reason was, I think, he was assisting Northern soldiers at first. Now, if he had assisted Southern soldiers, would that have been different? I hope not. I hope they realized this man was carrying canteens and blankets and clothing. He wasn't there to mount a counterattack. Now, Kirkland, who was known as the Angel of Mary's Heights, went on to fight in other battles. And he was about 20 years old at the time. He fought in Chancellorsville. He also fought in Gettysburg. And he was promoted to lieutenant. When the battle took place that I just talked about, he was a sergeant. And on September 30th, 1863, he and two other men led a charge near Snodgrass Hill during the Battle of Chickamauga. Realizing that they had advanced too far toward the unit, they attempted to return and Kirkland was shot. He ultimately died. And supposedly the last words that he said before he died was, "I'm done for, save yourselves, and please tell Pa I died right." He would ultimately be buried in Kershaw County, South Carolina, which is interesting because Kershaw was the name of the brigadier general. That was his general during that battle. And he was buried in the old Quaker cemetery in Camden. Now what's very interesting is Kershaw would later be buried in that same cemetery. Kershaw was his brigadier general who at first told him he could not go out there, but ultimately relented and said, as long as you don't wave a white flag, you can go. And that was an amazing cemetery because not only was Kershaw buried there, but so was the Angel of Mary's Heights, as well as Civil War General John Boudinot and his descendant, who was a World War I Medal of Honor recipient. And also a World War II Medal of Honor by the name of John Canty Villepique. In 1965, a sculptor by the name of Felix de Weldon unveiled a statue in front of the stone wall at Fredericksburg battlefield. That's where that battle took place that I talked of. And if you look, I believe it's on the top left of your screen, correct, Dan? Top right of the screen behind me, or to my right, you'll see the actual statue, which is a fallen Union soldier, and the Angel of Mary's Heights standing over, or actually kneeling over him, giving him some water. Now, I'm a student of the Civil War, and I've read many accounts of the bravery that took place during the war. And most of the bravery is during the battle. Now, this was after the battle. He was a guy that could have stayed put. He didn't have to venture out onto that field. And he ventured onto the field, in a sense, to give aid and comfort to the enemy. But those men were suffering. At that moment, they were certainly not a threat. And when I read this, actually, I had read something about this years ago, and I was watching a documentary on the Civil War, probably about a year ago. And they mentioned this guy, and they talked about the Angel of Mary's Heights. And I found it fascinating because, as I said before, many times I've heard of bravery. You know, Pickett's Charge, or in Gettysburg, all the battles that took place where people were being fired upon, and they knew that if they charged, they would probably die, and they did it anyway. And those men were brave also. Here's a guy, he was 20 years old when he did this. Think about that for a second. 20 years old. He was basically a kid, not long out of high school. And he had the courage, because that's really what it was. As I said, most people would probably sit tight and say, look, we'll attend to the wounded in the morning. He didn't do that. So that's the American that was exceptional on December 13, 1862. In closing, I would like to thank you for watching this show here on Altice. What I'd like you to do is, if you enjoy the show, you can also go to you could also go to YouTube. So if you missed the show, you can catch it on YouTube. Sometimes people turn the channel and they catch half of the show, or they have to go somewhere and they only catch the first half. Go to YouTube. You can watch it on YouTube by going to WLINY Internet Radio, and you can subscribe. It's just like going to Facebook when you watch something and you hit like and share. So I really would like you to do that. So if you like the show, we're going to be on next Saturday at 10 a.m. We also have the same show being run at 1:30 in the morning on Thursday. I always say, for you insomniacs. That's channel 20. This Saturday show is on channel 115. If you need any additional information about the show that you just saw, you can go to my website, JussinoLaw.com. That's JussinoLaw.com, JussinoLaw.com, or you can call me at 631-588-3155 if you'd like any additional information about some of the topics we discussed here tonight. Also, if you like a spirited debate about politics, you can also catch another version of Finding Common Ground. That show is on Friday nights. Every Friday night, I'm sitting right here at 8 o'clock. It's a live show. This is a tape show. So in the live show, we have more things we can do. We have a live chat room. So there's a big TV screen right above where I'm looking at right now, and people can actually make comments in the chat room when they watch the show on Facebook Live. So when I make a comment either about social commentary or politics, they can comment. They can agree with me, they can disagree with me, they can put their 2 cents in, they can make suggestions. People can also call in. We do have call-in guests. Usually that's reserved for people that I expect to call in at a certain time. The reason why I like to do that is when someone calls in, they usually monopolize more time than if someone just writes a comment on the chat room, and I can look at 5 comments in a matter of seconds. Whereas if someone calls in and is on the phone for 10 minutes, that cuts into the show. So I want to thank you for watching. Again, Saturdays, 10 a.m., channel 115. Thursday, 1 a.m., Channel 20, and the live version on Facebook Live and then YouTube, 8 o'clock, Friday nights. Take care.